You're live.
So good morning, this is Senate Health and Welfare and it's Friday, April 24th. It's always good to be Friday. Because the next day is Sunday. Tonight, let's see, we're going to take up 534. Katie, why don't you come up? We haven't really done anything to the bill itself, but we might want to look at it. I think it was one of those that seemed like it was smooth sail. See.
Good morning.
Good morning.
Katie McGlynn, Office of Legislative Counsel. Let me pull it up. Here it is. I will walk through it with you. It's been a while since you've seen it.
Thank you.
The only question the committee really had when we last looked through it was the timing of an assessment and a report. And I reached out to Lily Sojourner at OEO and to confirm that that was correct. And she did confirm that for us, that
The timing is okay.
timing and the clock is okay. Okay, so this pertains to the community action agencies. Right now in statute, they're called the community service agencies. So a lot of the changes you will see is updating that name. First, in the findings and purpose section, we have some language where throughout the draft, there's some language that's a little bit more antiquated. So some of the changes are trying to clean that out. So currently it reads, it remains evident that poverty continues to be the lot of a substantial number of Vermont's population. The change would be, it remains evident that a substantial number of Vermont's population continues to experience poverty. Then in subsection B, we have lead in that it is the purpose of the chapter to strengthen, supplement, coordinate efforts that further this policy through the better organization, utilization of a range of services related to the needs of individuals with low income instead of the poor. Same thing in subdivision 3. That brings us to page 2, section 3902. In subsection A, we're swapping out the name of the community action agencies. Same thing, it's subsection B, lines 9 and 10, and in line 11. And then on lines towards the bottom of subdivision B, on line 16, having person first language. So instead of designed to assist low income participants, designed to assist participants with low income. Instead of provide and maintain adequate housing and suitable living environment, swapping out with to have access to safe, secure, permanent housing. And instead of to obtain services for the prevention of narcotics addiction, alcoholism, and for the rehabilitation of narcotic addicts and alcoholics, swapping that out with to obtain prevention, intervention, treatment, and recovery services for individuals with substance use disorder. And again, subdivision 10, having person first language instead of low income persons, persons with low income. Subsection C, no changes. That brings us to page 4, section 3903. The strikeout community-based to community-based, the hyphen. So that is something that the editors changed when they were reviewing that should have been hyphenated.
Oh dear.
And then really the substantive change here is changing to community action agencies.
So that change happened before it got to us. So
yes,
we're not.
You're not making that.
We're not
change,
doing the
no.
phrase.
When it was drafted in the fall, when the editors looked at it, that was their change. So it was in the bill as introduced. Okay. 3904, Community Action Agencies Assessment and Plan. This is the section where you had the question on the timing. So each designated community action agency shall determine the need for activities and services within the area served by the agency every 3 years, complete an assessment, and incorporate that information into the annual community action plan. So the question that you had was that means and the same assessment influences the annual community action plan for 3 years. Because it's done, the assessment's done every 3 years. And the confirmation was yes, that is the correct order of things. The plan shall include a schedule for the anticipated provision of new or ongoing services and shall specify the resources that are needed by and available to the agency to implement the plan. And then striking out this, the community services plan shall be updated annually. You have captured that idea up above in line 13. Okay, page 5, 3905, again, updating the name of the agencies. You see that change appearing twice in subsection A. Subsection B are changed with the hyphen, community-based. And then on line 7, changing the name. And this is a list about who is serving on the board, the composition of the board. And it's really being reordered here so that persons with low income would be appearing first on the list. So now the new subdivision 1 will say a minimum of 1/3 of the members of the board are persons chosen in accordance with election procedures adequate to ensure they are representative of individuals with low income. And then what had been subdivision 1, the strike through in subdivision 1, is moving down to subdivision 2 on the list. And that's that 1/3 of the members are elected public officials. And then 3, we're not reordering 3, it's staying where it is. And then right now in subdivision subsection C, there is language about the term limits for people serving on the board. And instead that language is being struck through and there's a new sentence that each board shall adopt term limits to govern its members. So it wouldn't be in legislation anymore, it'd be the board themselves that is governing that process. And this takes effect July 1, 2026.
Questions?
Page 506, the number 2, a minimum of 1/3 of the members of the board are persons chosen in accordance with election procedures adequate to ensure that they are representative of individuals with low income. What's that mean?
They're individuals with lived experience of being low income individuals, and that the board itself will set up a procedure to ensure that 1/3 of its board is made up of individuals with that lived experience.
Okay. And who makes that? How do these individuals get on the boards? How do you?
How are they identified
Yeah.
and found? I don't know if I'm the best person to answer that.
Amy Scholberger, I represent CAP, the Montpelier Action Partnership. So all 5 CAP agencies are nonprofit organizations, and just like any other nonprofit, they would have an election procedure where either they're reaching out to people and encouraging them to run for the board, or people are self-identifying that they will come to the board.
Thank you.
Go ahead.
Other than updating the language, why are we doing this bill?
To update the language. I'll let Amy speak for this.
Amy Scholberger again. The actual, so this most of this language was in H91 last year.
Yeah.
The real reason is the board term limit language has really been causing a problem because it's a total of 10 years, but only 5 consecutive years. So the CAPs are having like people off the board and then re-invite them back onto the board. And so they are just asking to have the same rules as other nonprofits where they can set their own term limits as procedures for board elections instead of having it in statute. And you heard testimony from Josh Davis at SEPCA, explaining that a few weeks, it seems like a year ago, but it was a few weeks ago.
Right, he talked about the independence of the board and being able to have some choices in how people are selected, but also the length of time you serve.
In older days, when I was on these boards.
Yes.
I thought that the requirements were federal. I may have been wrong, but because there were term limits for low income, but I was appointed by the Montpelier City Council, and local government did not have term limits. I think of over 10 years, well, at least 10. I've chaired twice. So I was just wondering if maybe we're trying to reclaim it. Because these came in, these were part of Johnson's War and Poverty. These were things.
Yes, maybe you want to comment on that?
My understanding is the makeup of the board is reflecting the federal regulations, but the term limits, my understanding is it was checked and we can take control of the term limits. But the 1/3, 1/3, 1/3, I believe is a federal.
Yeah. And it wasn't elected, it was, or designee, must have been somewhere.
Yeah. Okay. Any other questions? So I know that Senator Gulick is very interested in voting on each of the bills that we're ready to pass out. But I would accept a motion on the bill, and we can hold the vote until Tuesday. If they're willing to do that, or we can wait and have a motion on Tuesday or Wednesday, given that we have a budget on Tuesday. I hate holding bills up at this stage of the game, honestly, but
Yeah, I mean,
yeah. I think this one she may not be unhappy with, so we could do this one. And it's a couple of the
I
others.
should move.
8:30, 5:34.
534 is, then we didn't make any changes, right?
No, it's the Ed House version.
Okay, well, is there discussion with any I can't imagine that Senator Gulick will have concerns. If she does, about the content of the bill, so certainly let us know. We can always do a further proposal amendment, significant. And then her concerns about not being able to vote, I think we can assuage those recently. Good. So,
Okay.
Senator Clerk.
Senator Benson? Yes. Senator Cummings?
Yes.
Senator Gulick is not present. Senator Morley, yes. Senator Lyons?
Yes.
401.
So. Good. I was hoping you'd say,
Once it's not Tuesday or Wednesday.
well, let's see, if you walk slowly up.
Bill and miscellaneous.
It would be on notice on Tuesday, and we can pass over. if
This
you're-
one will be a piece of cake.
That's what I thought. Thank you, Katie. So our amendment is not an amendment. Good work. So I think we don't have people here yet for 657. No, I just want to ask Melissa a question. Did you get in contact with the each other?
And they have it's not to speak, but I still don't
Okay, but we'll give them time for that. We have 660. Do we have a new?
We have a new draft of 660, you have a new draft of 816, and I, just in case we find ourselves with extra time, brought my folder for 536, which is the baby toxic foods, because you have a new draft of that also.
Okay, so I'm thinking that rather than diving into 657,
Mhm.
if we could move on to the other bills that we have.
Okay.
660,
Okay,
and I know it says 10 o'clock, but we don't have time to worry about talking.
okay.
Honest.
Then we'll pull it up.
I'm sorry. Which one?
660. That's the opioid settlement plan.
So you should have a draft 4.1.
Oh,
I can-
Yeah, it has that blue highlighting, which again, I know is very hard to read on a hard copy, but It's not so bad on the electronic version. Okay. So this is the latest version of the opioid abatement special fund bill. Changes you have made in the past are in yellow. Changes you haven't seen yet are in blue. There have been some changes where we're talking about a separate topic. So I've added in reader assistance heading. So that's what you're seeing on line 8. This is your list of appropriations from the opioid abatement special fund. The list doesn't look exactly the way you last saw it. Previously, there were items that were items 10, 11, 12, and 13 on the list. Those appropriations have been removed from the opioid abatement special fund, and instead you will see them later in the bill as coming out of the substance misuse prevention special fund.
So that's what the House tried doing, right?
That's what Human Services did, but the House did not have that. I wish Nolan was here, but there is money in the special fund, and I guess when it left the House, Nolan and others were under the impression there was not money. I hope I'm
The
categorized.
substance misuse prevention fund
Yes.
was, there was an indication that there was no money in that fund. And yet, but these projects belong in that, being funded there, because for the reasons that we talked about the other day. That the opioid misuse, the opioid fund, thank you. The opioid fund, must go to opioid.
Yeah.
Whatever.
I remember that discussion
Yeah,
early on.
and so that's what's really driven some of the changes that Katie is talking about, is how the funding goes, where the money comes from, what's available, and so on.
I just messaged Nolan to see if he is free to swing
Oh,
by.
good. If he can get here, that would be great.
You should always be the person talking about it, like, not me. So that's why in 10 and 11, you're seeing the blue highlighting. That's just because those sections are being renumbered because we removed some sections. So everything that had happened behind them is being bumped up the list. A new appropriation in subdivision 12. This is 1.1 million to the Department of Health for the purpose of awarding grants in Burlington to establish an overdose prevention center. Provided, however, that the department shall not distribute funding until the location for the overdose prevention center has been procured by lease or purchase. The overdose prevention center is being fit up for its intended use, and the overdose prevention center is currently or will imminently become operational. Oh, good timing on. And then we have this language that you see for some of the other appropriations. That is the intent of the General Assembly to continue to appropriate funds annually from the opioid abatement special fund through at least fiscal year 28 for the purpose of awarding grants to the city of Burlington for the operation of the overdose prevention center, unless and until the special fund does not have sufficient monies to fund this expenditure. And that fiscal year 28 specifically comes from last year's language where there was sort of a similar provision. No changes to section 2, which was amending a previous appropriation, the narrative around a previous opioid appropriation. Section 3 is where you have language about the opioid settlement advisory committee, and you have not made any changes to what the House did in that section. Section 4, you have some blue highlighting. This essentially is that you had other language and you're going back to what came to you from the House. Previously you had language that the opioid settlement advisory committee would not accept funding applications for fiscal year 28 from the special fund unless the proposal was previously funded through the special fund. What the House had sent to you was narrower, that they would only consider proposals that had been identified in statute as intended for annual funding. And this language brings you back to the House language on that particular piece. A lot of yellow highlighting, you've already seen this, so I might just skip over it for now to bring you to where the new language is. Okay. So I'm on page 8, line 10. We have a new reader assistance heading because we're changing topics. So now previously we've been talking about the opioid abatement special fund. Now we're switching to the substance misuse prevention special fund. And here is the appropriation of those 4 proposals that previously had been in your list in section 1. Now it's being moved here, so it's coming out of a different special fund, same amounts and same programming. So fiscal year 27, you have an appropriation to elevate youth services. In subdivision 2, Greater Falls Connections. Subdivision 3, 200,000 to Interaction Friends for Change. And subdivision 4, distribution to Winooski Partnership for Prevention. So again, those were in section 1 and now they're in section 7, coming out of a different special fund. Then you have in section 8, an amendment to the statutory language on the substance misuse prevention special fund. And this is to require annual reporting on the specific proposal that the Department of Health has for the use of that fund. So it reads, as part of its annual budget presentation, the department shall report to the appropriations committees and the policy committees on its specific spending proposal from the substance misuse prevention special fund for the coming year. The report shall include an estimate of the monies in the special fund anticipated to remain unallocated at the end of the fiscal year. And then we have our effective date, July 1, 2026. And then we have this blue language that the title of the bill is going to change to reflect the fact that it's not only about appropriations from the opioid abatement special fund, but it's now also contains appropriations from the substance misuse prevention special fund. So it's just an update when the bill is enacted that it will reflect both of those pieces.
So I have a question. So in the first part of the bill, you have the 10, 11, 12, whatever the numbers are. And are all of those moving down into underneath the substance misuse prevention fund? How's that organized then?
Yeah, so in the last version of the draft we looked at, there were about 15 subdivisions, 15 appropriations coming from the opioid abatement special fund. Numbers 10, 11, 12, and 13 of the previous draft. Those are the items that have been moved to the substance misuse prevention fund, meaning that any items that fell below that on the list now have a different number. They've been bumped up to a higher number on the original list.
But organizationally,
Uh-huh.
will those things that are funded through the substance misuse fund be down in that section?
Yes, so
Okay,
now,
that's all I was.
oh, I see.
Yeah.
Now those are all appearing in section 7. So you have 4.
Yes.
This had been 10, 11, 12, and 13. Now it's 1 through 4.
So they'll be gone from the fund.
Yes, they're gone now.
Just wanted to double checking. So I guess the question is, it's a question for Nolan. Before you came in, we were trying to understand when this came over from the House Human Services made one recommendation,
Yep.
something else. How did all of that follow?
For the record, Noel Lang with the Joint Fiscal Office, the Human Services Committee felt that those 4 items were more appropriate in the substance misuse special fund. Well, when it went to the Appropriations Committee, at that time, we were under the impression that that money was all allocated, that there was no money left in that special fund. So House Appropriations felt it was safer to put it back in the opioid special fund because there was money there. Since then, it's come to our attention that there is money in that fund, or that we're told that now there's money in that fund to be able to support these things. So we feel it's safe to put it back into this substance misuse special fund. There'd be just enough money to fund this.
Okay, so and it's more appropriate that they be in that, funded through that fund. That doesn't really fit with the opioid special.
I would say the Human Services Committee felt that was the case.
Yeah, I feel that way too. Well, I think we talk about that. All right, questions committee for Katie and Nolan. Thank you for sorting this all out. I know it wasn't easy. I think that, you know, going forward, we'll be able to get our hands around, our arms around, both the funds and the advisory committee. And then also with the reporting from the Department of Health on the substance, use disorder. Is that the right name?
Substance misuse prevention special fund.
Substance misuse.
Oh, substance.
Fund, special isn't part of the fund. It's a special fund, but it's not in the name.
Okay,
It's a substance misuse prevention.
Substance
but look at
misuse.
this is one. Substance misuse. So now we have draft 5.
Now you have to take out the word use. Substance misuse
Prevention.
service.
Substance misuse prevention services. Okay.
Substance.
Okay,
That's not the name of the fund. That's-
I'm gonna double check right now.
Okay. Yeah, I don't, Here's what I have, right? So what I will say about this one is I do think we should wait for Senator Gulick to come back so she can get this as a heads up on the changes that have been made, and we can look at this early next week.
I'll be back.
Thank you. Is that okay with everybody?
It is.
Yeah, I don't know how I'm gonna vote.
Uh,
Yeah, I don't, fine with me, but for waiting, I don't know how I'm gonna vote on.
okay. What's your question?
Uh. The 1.1, I get that,
Oh, the OPC,
yeah, which I get,
yeah,
and then the language just below it is basically tying that fund up. And I don't like that.
it's already tied up. If you remember this, Katie, can we talk about that?
Yeah,
Where-
so I pulled that language from last year's bill, so I'm duplicating it. Essentially, that was in last year's bill that there would be there'd be an intent for annual funding, through fiscal year 2028 for the OPC
Going directly to that one location.
in Burlington. Yeah, it was tied to Burlington. Again, legislative intent isn't binding. It's
Well, then,
it's
if we
an
take it out, then.
it's an aspirational statement. But, now that you have limited, now that you've gone back to sort of the House proposal,
Yep.
which is that you can only, that there can only be, applications in fiscal year 28 for items that in statute, there has been an indication for ongoing annual funding. If you didn't have that language in, you would maybe preclude funding for that for next year. Does that make sense? Let me try again. So. like
Because the
said-
way I understand it, you have this committee,
Mhm.
Okay,
not to
so
make recommendations.
we need to go back even further.
Oh,
So with OPC, when it was originally put in place and the affirmation was to fund it through 2028 with this amount of money to get fit up and then they'll begin operation, but not continuing after that. So this is a commitment that was made. I don't remember the date. When it was first put into place last session. Or the session before.
I think maybe the session before.
Yeah, so it's been an ongoing commitment. The hitch that concerns us is that Burlington does not yet have a venue. They haven't signed a contract. They don't have a lease. They're not doing it. And I also have concerns that times are changing. Okay, so, but in the meantime, we did make that commitment legislatively, as did the advisory committee. So this just is reaffirming that commitment and keeping it in front of us.
Yeah.
That's it.
I'm just surprised the advisory committee didn't have it in that budget.
Who didn't?
The advisory committee didn't recommend it in the.
No, they did not. But it is a commitment that was
Yeah.
made. Yeah, that's right. So do you know the date? You know,
When it originally
Yeah.
happened. No, I don't, I could look it up for you, but I don't have it at my fingertips. I was guessing it was at least 2 fiscal years ago. But when I drafted the language last night, I pulled the language from last year's act.
so it's just like an ongoing commitment. And if the thing doesn't happen, it all refers into that.
Something that was gonna be my question.
Yeah.
Because next, I mean, we're putting the money in for 27. That means one more year. And at the end of 28, it would say they've accumulated several $1 million. And if we're not up and running at the end.
Well, there's nothing about that, but at
That's
the
what
end of that, that's the money you've got.
Right,
Either do it or,
and so I'm just curious,
Yeah.
so how long can they sit on?
Cause they had 2.2 and then they spent like 400,000. As I recall, honestly, I
Exactly.
remember.
Yeah.
So now they'll have another 1.1 and they'll get another 1.1. And I'm just curious as to, in terms of stewards of the money, if in fact we get to the end of 2028, they still don't have a lease, still don't have a program, how long can they hold those funds before they come back to being
Better
used?
tell them to spend it.
it's gonna be a fun discussion. Just so you know, I have been in contact with the mayor of Burlington and others about this, and we'll continue that dialogue. Cause I share your concerns. And keep, and I think that Burlington feels uncomfortable about it as well. It's a tough situation for everyone. Oh, we'll see what we can do. Okay, so let's hold this bill. We'll look at a clean copy. I'll put it down one day next week
Okay,
when Senator Julich is back, and we can, we don't want to overstep our role too much. I don't think we're doing that with any of the language that we have here. But we certainly can talk with the Department of Health is sitting right here with us and hearing us. But it would be important, I think, for the advisory committee to take up the issue about the longevity of some of these things. There are other programs, obviously that are receiving money, and they could receive as much as the OPC is receiving. And how long will it take for them to implement their program? So we want to make sure that once the money is available, A, it goes out the door for ready projects, and but B, what happens when projects are not ready? That's I think the reason for having the hiatus in the bill that we have with that Human Services put in, that there's a hold time on new projects to evaluate what's going on overall. I think that's a good thing.
I just sent an updated draft Callisto with correcting that title heading in section 7. So if you're looking at it over the weekend, it's draft 5.1 is the most recent. version.
Okay, good.
Yeah.
Yeah, this is really well. All right, so we'll put this one out for next week for our, hopefully, lots of discussion on it and see what we get to. And then, we still have a little time, Katie.
Mhm.
What do you suggest?
Um,
8:16?
We could do 816, or you could do H536, the toxic baby food. There are fewer changes in that, but
Well, we can look, let's see,
either, whatever you want.
well, I know in both of those, we're gonna have to hold over for Senator Grulich. She's very interested in them, but let's see what we can do. Let's look at it. Just surprise us.
Surprise you, okay?
I know,
Let's see.
baby food isn't on the list, but that's okay. We can do.
Do you want to do that? Okay,
Sure.
I have that open, so
Sure.
let me pull that one up. Okay. So here is this is your first amendment. You heard testimony from the AG's office, and I was asked to integrate those changes into this draft. I also, made one of my own changes reading through, so I'll show you where that is. So if you remember, we have our section on baby food products, we have definitions. And then we have a sentence that says a person shall not sell, distribute, or offer for sale any baby food product in the state that contains a toxic heavy metal that exceeds limits established by FDA. But when I went back and looked at federal statute, it's called a regulatory limit, not just a limit. So just to use their terminology, I added. This comment is highlighted because just to remind me really to talk about it, that this paragraph had been organized differently and I moved some of the clauses around and it made it more readable to my ears at least, but I haven't lost any of the content. So this reads, without requiring the provision of a universal product code or proof of purchase for each baby food product sold, manufactured, delivered, held, or offered for sale in the state, a manufacturer of baby food shall make publicly available on its website for the duration of the product shelf life of a final baby food product plus 1 month. So I just sort of reorganized that needed language. More substantive changes. In your Consumer Protection Act language, if you remember, the AG's office did not want the list of everything that could be done under the Consumer Protection Act. So this sentence has been shortened to read that the Attorney General has the same authority and private parties have the same rights and remedies as provided under 9 VSA Chapter 63, Subchapter 1. The other request by the AG's office was that the Attorney General could not or was not in a position to know when there was a not sufficient amount of infant formula and asked to consult with somebody. So this has the Attorney General consulting with the Commissioner of Health to make that determination. She'll suspend the application of this section to infant formula if the Attorney General verifies there's insufficient infant formula in the state to meet the need or evidence of a declining supply. That was also a recommendation of the AG's office, not to wait until there's already insufficient infant formula, but there appears to be a declining supply. That is an okay time to suspend the application, the application of this bill to like that. And those are the changes.
Questions for Katie?
Don't remember hearing testimony on the formula, but there was the infant formula.
Yeah.
Are other states doing that?
No, so this doesn't take effect immediately. Section 1 of the bill takes effect in the short term. The piece about it being applicable to infant formula doesn't take effect unless there is a contingency that is met. So that contingency is right here, subsection B. It takes effect on the AG's written confirmation to the Speaker and the Pro Tem, which should be posted on the General Assembly's website that either California or 2 other states have enacted legislation with requirements substantially comparable to the requirements in this act regarding each of the following.
I remember.
Yeah,
Okay, so that's the formula.
that's the formula.
What about the food?
The food takes effect on a date certain, takes
Yeah.
effect January 1, 2027.
Any other state?
Yes.
Yeah,
Okay,
yeah, a lot of them.
Quite a few have done that.
I just want to make sure.
Well, I was thinking about the manufacturing companies since they're already doing it.
Right.
So
That's
can,
fine.
I wasn't sure about the infant. That's why I asked about the
Yeah.
infant formula.
And there was some discussion on the formula about whether it should be tied to the states or to a population.
Yeah. And you're doing pretty good.
You guys are really frequently titled, so it's just scary.
Yeah. Hey, you've done enough teaching us.
Okay, so this will be good. Let's, well, I'll try and get this on the agenda when you're in next week.
Okay,
You know, and these, the bills that we've just talked about shouldn't take that much time, so we'll put it on. If I can get it on Wednesday, we'll do it. I forgot.
Okay.
Yeah, no, yep, you might be here, you might be here, we'll match some time at the end of the day. Stay next. See how that goes, it's either Wednesday or Thursday.
Okay.
Friday. Could be fun. Yeah,
You can surprise me.
all right,
Okay, would you like the 6 to 8:16?
yes, please.
Okay. Okay. Here it's 8:16. Our highlighting is the same as previously. So yellow is previous changes you have made. Blue is new since the last time you've seen the draft. So you have your purpose section. You have a section on unprofessional conduct. And when we last met, there was a suggestion to change the wording on this. I think said maybe something about misuse of artificial intelligence. Now it's referencing a mental health professional engaging in the prohibited use of artificial intelligence to capture this heading. So we're cross-referencing it and we're using the same terminology. So this is saying if a mental health professional who's in a profession regulated by OPR violates this 7115, then OPR can hold them responsible pursuant to their existing authorities. Okay. So then we have our definition section. I don't believe we had changes here. We had definitions of therapeutic decision, therapeutic communication.
Okay.
Here in B, if you remember when we last met, we said this is really one of the most significant sentences of this act, and that is that an individual, corporation, or other entity shall not offer or provide mental health services through artificial intelligence without the review and approval of a mental health professional. Previously, it had said involvement, and the committee decided on review and approval. And then subsection C, a violation of this section by a corporation, an entity, or an individual who is not licensed, certified, or rostered as a mental health professional shall be deemed a violation of the Consumer Protection Act. And again, we have that same language being removed as we did in the previous draft. So now this sentence is that the Attorney General has the same authority, and private parties have the same rights and remedies as under Title IX. So that is the change here. And this corporation, entity, or individual who is not licensed, certified, or rostered, that is picking up the language here, individual, corporation, or other entity. Okay. In subsection D, this is the language specific to a mental health professional. Nothing in this section precludes the professional who's operating within their scope of practice from using AI tools that are compliant with HIPAA, provided the mental health professional reviews and approves, same language as above, any mental health services. Previously, it said something about maybe therapeutic decisions and communication, because those are embedded in the definition of mental health services. You chose to go with mental health services, which was more comprehensive. Okay. And then we have a new section. This should be highlighted in blue. I'm sorry, I highlighted in the wrong color here. So this is a new section. If you remember previously, we had a penalty section for all professionals who are OPR regulated. But some of the professions in the list of mental health professionals are regulated by the Board of Medical Practice. So this picks up those professions who are regulated by the Board of Medical Practice. And it pretty much is parallel tracks, very comparable. So for professions regulated by the Board of Medical Practice, unprofessional conduct includes engaging in the prohibited use of AI pursuant to the section that we just looked at. Let's see, section 5 is highlighted because it's bumped down the list, and same thing for 6. And this takes effect on passage. So those are the changes that were made since you last took a look at this.
Okay. Go ahead.
So question that was raised to me from a legal standpoint is, do we even need this bill? Because if AI is practicing, they don't have a license to practice. Therefore, that would be an illegal activity. So, you know, if AI is out there on its own,
Practicing
not
marijuana.
right,
Right.
it basically has no license to do so.
So I think what you're saying is could OPR, find an AI chatbot for unauthorized practice?
Correct.
That's an
That was-
interesting
that was a
question.
that
Yeah,
Was raised to me, not the attorney, so.
yeah, that's an interesting question. I think probably OPR would be best able to handle that. I don't know if they have capacity to enforce against
Interstate commerce.
an electronic entity that's not a person. I think probably their unauthorized practice is directed to a human who is,
I just thought it was an
Yeah,
interesting
I think
question.
it's an interesting question. I would say OPR is probably better equipped to handle that than I am.
It's probably the following body of law.
Yes, I think it would be an interesting court case.
And, you know, this, if that were an avenue for OPR, this, would create a parallel track for the AG's office to also do enforcement for that type of behavior. But again, OPR would be better to opine on that than me, I think.
Okay. So this is good. Any other questions? Well, it'll end up, your question is the kind of question that ends up with a federal hearing that says this AI has destroyed my child's mental health or my husband's mental health. And then it goes into another Supreme Court case or federal law. Yeah,
What is the legal standing of a body?
right. I think what we're saying here is we want human beings involved in the mental health
Decision.
process. Yeah. Essentially. So anything else you want to see changed in here, have questions about besides the underlying philosophical question? Senator Benson's question. We'll have to get Jen Capone in here. All right, so let's put this one also out. I feel good about what we've done with it and where it is. And so we'll take some time next week to add this one along with 536 and 660
Okay.
as soon as we can get it there. I have no promises about when.
Mhm.
Partially will depend on where we are with 938 and our other big bills.
Okay.
Thank you, Katie.
Yeah, you're welcome.
Let's take a 7-minute break offline.